Hello, once again, everyone, and welcome to the Legal Power Hour, where we jam 60 minutes of thought-provoking discussion into a 30-minute show designed to inform, awaken, and protect our fellow American citizens. We are your co-hosts, Tom Scott and Sarah Nahidi, and today we are happy to welcome back with us to the show Mr. Bill Scheidler, Chief Activist for CorruptWash.com, a website that exposes judicial corruption in Washington state. Welcome back to our show, Bill.
Hi, Tom. Hi, Sarah.
Thank you for being back on the show again, Bill.
Thanks for having me back.
So do you want to tell the viewers a little bit about first, what got you involved in the legal system, and then number two, where your cases are at currently?
Yeah, my background's chemistry, so I had no intentions of ending up in court. But what got me into court was actually a document that's published by our county, and the document misstates a law that would misdirect anyone who reads the document. In other words, the instructions the county was publishing were erroneous, and if anyone followed those instructions, they would not achieve the purpose for which the instructions were intended. And the purpose was to give retired people a break on their property tax. So it was all designed basically to deny the property tax exemption, and that, of course, brings in more revenue. The more denials the county can issue, the more tax revenue they collect. And so the incentive was to mislead citizens. So that's how I ended up in court. I tried to resolve that issue directly with the assessor to have him just simply correct the misstatements, and he didn't. So I'm in court and been in court trying to get a jury to take a look at what the assessor was publishing versus what the law said he should be publishing and make a decision. But the judges keep throwing the case out. So over the next, I'd say 15 years, I've been in courts, having my cases dismissed, going to appeals, having the appeal courts remand the cases back to trial courts, which then are dismissed again. So it's nothing but this hamster wheel of trying to get one simple issue decided, and I just can't get it decided. It's still, right now, it's at the U.S. Ninth Circuit Court of Appeals. I'm seeking en banc review because the appeal affirmed the dismissal. So my next step is en banc review, or I guess appeal to the U.S. Supreme Court.
And Bill, why are the courts dismissing your case? I mean, on what grounds is the court doing this?
The grounds, what's interesting is the grounds have nothing to do with the analysis of the documents. It all has to do with court rules. They're saying I either don't have standing, or in this case specifically, my case was filed in state court, but the defendants, that is the county prosecutor who represents the assessor, removed that case to federal court and immediately motioned for dismissal under the state's immunity. Now, when by law or by the case precedent, when a state removes a case from state court to federal court, they're supposed to waive 11th Amendment immunity. In other words, you can't take a case from a court which has jurisdiction, move it to the federal court and claim the federal court doesn't have jurisdiction and get the case dismissed. It leaves you nowhere. You have no court to plead your case. So that's the game they've been playing, is claiming immunities or that they don't have. The appellate court reversed because of the argument I just said, but then they dismissed it under qualified immunity and other kinds of immunity. So it's just roundabout where everybody's claiming they have immunity from suit, never mind whether or not they're doing their job correctly. They're just claiming they can't be sued. So that's the hurdle that I can't get over, and and basically the basis why the case has never been decided. I don't know. Does that make sense as to the process?
I mean, it makes sense to me. I mean, I don't know if our viewers know what standing means. So if you could explain what standing means, I think that would be helpful.
And well, basically, in order to bring a lawsuit, you have to have some sort of injury. You have to say this conduct injured me in this way. And in my case, I'm saying the instructions that I was forced to follow caused me to miscalculate the income, and due to the faulty instructions, and because I was forced to miscalculate the income, I didn't get the benefit the Constitution provides. So that's the injury, is I haven't been provided the benefit because the county is misstating or misrepresenting the law. So that gives me standing. The problem is they're all claiming that they're immune from any liability. So that means I can't sue them. Sorry? Oh, I'm sorry. I heard something. But anyway, that standing generally means you have to have an injury that can be compensated for in order to bring a case. And in my particular case, although I have an injury, I can't be compensated for it because they're all claiming they have immunity and they're not liable. So the case gets dismissed. I appeal. It gets reversed. But then I don't know, the judges, in the last case, the judge just said the appellate court wasn't quite clear on what it meant. So he just went through the dismissal again.
That's incredibly frustrating. And I can't even imagine. I mean, I know you explained briefly what immunity is to our viewers, but where does the idea of immunity come from? Where does this, stem from?
Well, this is the argument I'm making is immunity is, as far as I know, and as far as those I've consulted, comes from the common law that stretches back before the U.S. Constitution. So it's not anything that is, they call it positive law or laws passed by the legislature. You can't find that people have immunity from lawsuits based upon statutory immunity. So this is all common law immunity, and judges have declared that they have immunity. And because they have immunity under the common law notion, they start granting immunity to all their friends and whoever they feel is performing a judge-like function. The thing is, in Washington State, there is both a constitution and statutory laws that prohibit immunity. In other words, they cannot claim immunity in Washington State because under Washington's constitution, immunities are prohibited. And in fact, the common law that they rely upon granting or claiming immunity has also been legislated and says common law that conflicts with our Constitution is not valid. So, but judges don't care. The prosecutors don't care. They're going to simply raise an immunity defense, and judges generally don't like to. Well, in my view, they don't give pro se litigants the benefit of the doubt, or even, I think, read the laws that the the pro se might even put in front of them and say, hey, here's the law. How is it you're granting immunity? They'll just take the word of the prosecutor, dismiss the case, and then that puts you on the hamster wheel that, stretches years, decades in my case. I don't know if I explained that.
No, that makes sense. And that's, again, incredibly frustrating.
Yeah, it's, go ahead, Tom. I'm sorry.
Yeah, Bill. Yeah, just a couple things. Like you just said with immunity, both prosecutorial and judicial immunity, there's nothing in the U.S. Constitution about that. It derives strictly from common law. There's nothing that guarantees these people immunity whatsoever. And as you just said in the Washington state, the state constitution explicitly declares there would be no immunity. So they're kind of going, doubly over their standards. And then the other thing that you mentioned too about pro se litigants putting forward, whether it's statutory law or case law in court briefs, pleadings of any kind being ignored, I can pretty much testify to that fact. The appellate court in the People's Republic of Massachusetts, I put all kinds of, heavily quoted statutory law that was completely ignored time and again at two different levels of appeal in that state. I mean, it's almost like a shell game. I think what they do is they write their opinion to the party that they want to win, and then they backfit it with whatever case law that they can cherry pick to support that argument. I think that's really what it boils down to. And that leads me into the question to you. Have you seen any overt corruption in this case? Court records being doctored, phone calls being made, behind the scenes dealings. I know Washington, Massachusetts, and Ohio are outrageously corrupt. And I just want to know what you've seen with your experience.
Yeah, it's, I think from my experience, knowing what the facts are in my case, and then reading the opinions of the judges, and they don't include or even reference the facts, in my mind, that's corruption, where, if they're trying to ignore the facts that would defeat their intended outcome, they simply ignore those facts. So that's the type of corruption that I've encountered. But also I sit in as like a case watcher or a court watcher, and oftentimes, just as you said, that the judges either take the pre-written order that one of the parties might file and then formulate, an opinion from the bench, just reading that opinion. And one time, the judge started to issue her verbal order, and she got mixed up as far as what place she was on what document she was reading, and she looked to the counsel or to the side she wanted to support, and she said, "Am I saying this right?" She actually asked whether or not she was repeating what they had agreed, as far as what the order would be. So, I mean, in my mind, that speaks of what's called ex parte contact on how to, it's a tag team. They all play
right
behind the scenes so that the whole charade is acted out once they get into court. So I see that all the time, hiding evidence, mistake, ignoring the law, ignoring the arguments, ex parte contact. It's all live and well up here in Washington State.
Wow. Yeah, I mean, I'm just curious because, I have a case that's in the appellate court, and I've seen judges commit criminal acts on the bench. The criminal law says to not do X, and they do X anyway. I've had a lawyer named Joseph Michaud commit conspiracy to commit fraud by conspiring with the court clerk. He's committed perjury, which I can prove, and he's also committed obstruction of justice, not once, but 4 times. I've had them disregard facts. I've had them doctor the court record. What else? You know, I know phone calls are made behind the scenes because of happenings that occurred within the case that could only have happened if one person had spoken with another. So I've seen this myself, you know, and that's just one civil case. I'm not talking 12 cases. You know, you would think all these things happen. Wow, that's too much for one case. That's just one civil case.
Yeah. I think all that goes on. You know, it's just play acting when you actually get in court and they say court's in session. I think it's already predetermined who the winner's going to be, and it doesn't matter how right the other party would be or the law. I mean, in my particular case, because this has to do with unlawful taxes, the consequence in actually addressing the misstating the statute or misstating the law in order to levy an unlawful tax has tremendous implication on the county's liability. All of these people who have misstated their income because they believed that they were following the correct instructions, they would all have a case to come back and say, hey, you know, refund all of these illegally obtained, you know, dollars. And that could be hundreds of millions of dollars if every county was doing the same thing. So there's a financial motive to not do the right thing. In fact, the financial motive of judges is to actually cover up the wrong thing, because the financial consequence to the county would be so staggering. And in my case, the judge who sat on my case, his wife was manager of a law firm that actually had advisory responsibility to the county's risk pool, meaning the insurance funds that the county would have to tap into to pay these liabilities. So we have a judge whose wife is advising the county about the insurance coverage, sitting on a case that would involve the insurance coverage if I would win my lawsuit. So that in itself is corruption. It's a conflict of interest in the judge having his wife involved in a matter that the outcome would affect her job and you know what she does for the benefit of the county's insurance business.
Yeah.
So,
Bill, did you bring this to the attention of the judge and ask the judge to recuse himself?
I did. Yep, I did. I filed it in a motion. We sat. That was the only hearing I was given, was to come in and argue my motion for disqualification. He said it wasn't significant, and he refused to qualify. I went for a writ of mandamus to force him to qualify. The appellate court said I didn't present any fact. I mean, I just explained the fact on why I was asking for disqualification, but the appellate court said no, I didn't present any fact, and of course the case was then booted, and now I'm back in appeal. So, I mean, how do you deal with a system that denies the facts that are presented and claims there's no facts? Well, does what the law prevents them from doing. I mean, it's I don't know. It's like we said, it's time for a revolt, revolution, or civil war, I guess.
Bill, have you gone outside of the system and asked to speak directly to your local representative? I mean, have you thought about, you know, speaking to local politicians that could potentially redress this issue?
Excellent point. And in fact, our local legislators have a duty under our Constitution to address judicial misconduct and these very things. So I went to my local representatives. They agreed with me. They even asked me to draft what's called a referendum that they would then submit, as they're required to do, to the full body of the legislature, which I did. And then it was, I guess somebody told them not to do it, but it was never done. So,
and you followed up with them and asked them, why wasn't this done? I want this to be done.
Yeah, I followed up with them. And basically what they're saying is that there's no chance that it would pass the full legislature. So they're not going to pursue it. So they just took it upon themselves to say, no, it's not going to pass. Therefore, we're not going to pursue it. That's not really the way the constitutional.
It's not how it's supposed to be. It's not up to them to say it's not going to pass. They still have to present it and see it through that process. And the council will decide if it passes or not.
I agree with you. And that's what my argument was. And when they didn't do it, I actually filed a lawsuit against them for a breach of their duty. So, and of course because it has to do with holding judges to the law, and I had to file it before a judge, it got tossed as well. So
did they say that they were immune from law?
Yep. They all have immunity. Legislators have immunity. Judges have immunity. So it doesn't matter that what they do is not lawful. They claim they can't be sued. They have immunity. So
amazing.
It's I don't know if it's correctable. I think we have such a corrupt system, a house of cards, that it's now too big to fail. There's too many. It's so corrupt that as soon as you try to fix any one little bit of it, the whole house of cards is going to start falling down. So they continue to try to cover up and protect their little industry they have going.
Yeah. One thing, Bill, the whole thing with the corruption, like you just said, Sarah and I, we write about this in the book, and we think the number one problem is that the system really and truly has no competition. And we make the analogy having a Lowe's in town without a Home Depot. I think if the founding fathers had set up a parallel court system to rein in this one, I think things would be very different today. I don't think we'd see this because, you just kind of pretty much summed up what we say in our book. It's a monopoly. It's basically a monopolistic corporation with no competition, right?
Right.
What do you see? What have you found most challenging with this case? What has really frustrated you the most?
Well, in my mind, the right to present your grievances to a jury. I mean, to me, that would end it. That would be the people exercising their political power and deciding what is right or wrong. When our Constitution says all power is inherent in the people, and you're prevented from bringing an issue before the people, as in a jury, then someone else is claiming all that power. It's not the people anymore because they're represented by the jury. So the biggest frustration is, can I get my issue before the jury who represents the people and all the power? And if that simple request was honored, as our Constitution in Washington provides, it says a jury is an inviolate right in both civil and criminal actions. My case, we wouldn't be talking. It would have been decided in 1998. I would have had my case decided by a jury back in 1998, either for me or against me. But at least it would be the decision of the people, and not these judges who are deciding for themselves that they have all the power. So that's
yeah, yeah, right. And just to add to what you're saying, they do have all the power. In fact, only I think it's 97, 98%, and 95% respectively for both criminal and civil cases ever don't see jury trials. It's only a very small percentage of cases in our judicial system that ever get put before a jury because of this monopoly.
Yeah, and they don't want to give up control because to do so, their jobs are now at risk because now they're susceptible to the same accountability as everyone else. So they have to find a way to maintain their power, and the way they do it is to deny the people their power and our rights. I mean, I'm sure there's other motivations behind that, but I think the keeping power within their sort of little group is prime motivation. But I don't know. What do you think?
Yeah, I agree. It's just it's kind of an industry that feeds itself. That, like you said, if they lose power, then they lose income, they lose control, and it's a self-fulfilling prophecy, basically. Do you see things in Washington getting worse, the same, or what? I mean, how do you perceive I didn't realize your case went back prior to 1998, 20 plus years in one case, and that's not unheard of. I know somebody in the People's Republic of Massachusetts. She's been in, I think, for 27 years, 26 years, something like that. What do you see in Washington? Is it still getting worse?
I think it's worse. Whether or not it's their last, maybe it's their last attempt to circle the wagons and keep control. But I also believe that we're now in the age of communication that reaches far more people. For example, you're in California, and I don't know where you are, Tom, but I'm in Washington State, and this is going to be published all over on the internet, so more people are going to become aware of it. And whether or not that gathering of many voices is going to help bring about change, that's what I'm hoping happens. But so far, I haven't seen it. But that's what I'm hoping, will be the result of the ability to have mass communication and address these issues the way we are.
Yeah, I mean, that's why we wrote our book, was to focus on the education piece, but without actually unifying people and executing action. The education piece doesn't do a whole lot unless it's actually implemented. So we need to get people to come to the table, realize the problem, and figure out ways to implement change.
Yeah, I just wrote I sent 2 packages to the Commission on Judicial, I forget what it's called, the Oversight Committee, the Senate Oversight Committee and the Congressional Oversight Committee. I forget. I think they have jurisdiction over the FBI. So I've sent a couple of packages off to them, and I'm hoping others, send packages off and alerting them to the 3 issues that I think need to be addressed. Has to do with the courts using their court rules to abridge, modify, and enlarge substantive rights. And that's prohibited by federal law. There's a federal law that prohibits court rules from abridging, modifying, or enlarging substantive rights. So when a judge denies a jury trial, that is a substantive right of both the litigant and the people, they're misusing their court rules. And then the problem is when a judge misuses the court rules, your only avenue is to appeal it to another bunch of judges who have the same interest in misusing or using their court rules to retain power. And that's also a violation of a federal statute that prohibits judges from ruling on matters that they have either a direct interest in, a bias in, or any other fiduciary interest. So based on those two violations, I think if the FBI or somebody, if they would come down and force judges to live within the laws of the United States, that would go a long way to solving a lot of the problems that I'm finding. But whether or not the commission, I forget what it was, Judicial Oversight Committee or something like that. But I write these letters, but I never get a response back. So where do they end up? I have no idea.
In the North Pole, obviously.
Right. So, but what? I'm sorry, Tom.
I was just going to say, so Santa Claus is getting your letters instead of the people responsible for these problems.
Yeah. Yeah. But I don't know. What ideas do you think need to be pursued to sort of come up with some sort of plan? People don't like to get off their easy chairs and actually do something that would require a little effort or a little work to accomplish. So it's difficult.
Yeah, that's right. And that's Americans personally have some great characteristics, technical know-how, the ability to unite when we have to, ingenuity. You can go down the list of some good qualities. But I think the number one problem, you just hit right on the head. People like to go to social media and bitch, but they just don't get off their ass and do anything about it. I mean, that's what we're trying to do with this show. That's what we're trying to do with our project. And other people on our network are becoming more in tune to that. But I wish we could get over that hurdle. I really see that as the blocking point of really getting this thing into orbit and regaining control of the country. But we are trying. Hard to believe we're actually just about out of time. I have one last question for you, Bill. If you were to estimate the number of hours you've spent in this project, how much would it be? I'm going to take a guess at around 2,500 hours. I'm probably short, but what would your number be for the amount of time you put into this particular case?
This case, oh my God! Well, I don't punch a clock when I sit down and do something. It's always on my mind. It's thousands of hours. I mean, it consumes you because one, you have to kind of process the notion that we don't have a just system. We're dealing with, in most cases, people who violate the law and get away with it. And no one else cares. So, that in itself consumes a lot of your time. But yeah, you're right. Thousands of hours.
Yeah, that's what I would have thought.
Could have been better spent doing something more productive and positive.
Yeah, absolutely. I mean, like I said, if a jury would have heard my case, I would have been behind me back in 1998.
20 years ago.
Yep. And I still can't get in front of a jury. So, but
Thank you so much, Bill, for coming on the show again. We really appreciate it.
Thanks for having me, Sarah, and thanks for all you do. The book you wrote, I read through it. It's filled with all kinds of helpful suggestions and observations. So thank you and Tom for all that you do.
You're welcome, Bill. Thanks for those kind words. It's very appreciative. We sincerely appreciate that, and probably have to have you back on our show again. I'd like to close the show now to tell our viewers to catch our show fresh every first Monday of the month at 7 p.m. Eastern Time, or view it anytime afterward right here on our YouTube channel. Be sure to subscribe to our blog for informative monthly posts at www.stloiyf/blog. And if you want to protect yourself to the fullest extent possible against our wildly corrupt legal system, pick up a copy of our book, Stack the Legal Odds in Your Favor, that Bill just alluded to. And if you would use the link below this video, you would help support Bill and his efforts up in Washington State as well. So once again, Bill, thanks so much. And I personally wish you the very best success in your case. If there's anything more we can do, don't hesitate to reach out.
Okay, thank you very much. I appreciate all you guys
Thanks
and
again.
what you do. Okay, bye-bye.
Bye.